Hello, everyone. Thank you so much. We had few technical hitch. Tonight, I am here to take viewers through the employment law, as I said right for my intro. And we are going to look at a very interesting topic. Obviously, COVID restrictions have come to an end, and therefore, for those of you who have been working remotely, I'm sure by now some of you have received notice that you may have to return to the offices or your workplace. So tonight I'm going to look at people's right under the Employment Right Act and what they can do if, for example, it is favorable to them to continue to work remotely. As I've said earlier, I had a friend who said that he has to resign from his job because of the fact that he was asked to return to the workplace or the office, and where he has recently acquired a property is quite far. So I'm sure most of you will be having these challenges, and therefore tonight is an opportunity for me to take viewers and listeners through the employment law so that they can know their right. Now, to give a background to what I'm going to do tonight, if you look at the Employment Right Act 1996, which was amended as Employment Right Act 2002, that law came into effect on the 6th of April 2003. This law originally was about right to flexible working. Now, so around 2007, there was a further amendment that if you had dependents or you have dependents who needed care, then you are eligible to request for flexible working. And then eventually there was a regulation in 2014 which made it quite not mandatory, or you don't have to have any specific or specified reasons to in relation to having a dependent or somebody who needed care in order to request for flexible working. So the right to flexible working has been there for a long time, and therefore people who have been working from home due to COVID, who may, one reason or the other, may want to continue to work from home or work remotely or do what they call hybrid working. Now, so first and foremost, let's look at what is right to flexible working. Now, when you want to work flexibly, it means that you either want to change your hours, you probably want to do a shift work, maybe you want to work night, or change to daytime if you are working night, or maybe you want to change the location where you are working, or perhaps for one reason or the other, you want to reduce your hours and do part-time work. Now, it might interest you to know that this is something that is quite established by statute, but most times employers just simply ignore people's requests. Now, what does the law say? The law makes it clear that if you are somebody who have been employed for 26 weeks or more, then you are entitled to make a request for whatever reason, a request for flexible working. Now, if you make that request for flexible working, what does the law say regarding employer, what that employer should do? The law makes it clear that that employer needs to consider that request and must give you written reason within 3 months. So let's say I'm working in London, maybe I bought a house in Bristol, or I bought a house in Birmingham. I'm working for a particular organization which has branches all over the UK, and therefore I want to ask for change of location of my workplace. Or let's say I've been working remotely, or because of COVID, I've been working from home. And I realized that due to COVID, I can continue to work and still care for my younger children at home and use my lunch break to pick them from school and then bring them home. And this saves me money that I would have spent on commuting to the office. It also saves me money that I would have spent on childcare if I was to go to the office. But obviously, I have been doing my work as somebody working from home without hindrance. And this arrangement is beneficial to both the employer and to myself. However, if for one reason or the other, the employer decides that I should then return to the office, what do I do? Because I have an arrangement that has been in place since COVID that is quite beneficial to me because of these reasons I have just enumerated. So the law makes it clear that if the employer so decides that you should return to the office or to the workplace, then of course you have the right to also request that you want to continue to work either remotely, working from home, or to do what they call hybrid working, where you work 2 days at home and then a day or two at the office. Now, if you make such requests, the Employment Rights Act 2002 makes it clear that the employer has 3 months to consider that request. And if the employer decides to make decision on that request, you are also entitled to be accompanied by a work colleague or trade union member. And if the employer decides that he wants to refuse that request, there are mandatory grounds for refusing that request. And those mandatory grounds are, for example, this request will not probably allow the employer to be able to meet customer needs. It will probably not make the employer, to make it difficult for the employer perhaps to get an alternative staff or even to recruit someone else to do that bit that you would have gone to the office to do. And many more reasons. But here is the trick. The trick is that if during the COVID you have been working from home for such a long time, for almost a year or two, then it becomes more difficult for employer to say why you should not continue to be working from home, but rather you should come to the office. Because obviously, if the employer is refusing your request, then that employer needs to give a reason. And that reason, there are mandatory grounds. Either that arrangement is going to cause the employer financial loss. But as I've just said, it's probably going to be very, very difficult for the employer to say that it's going to cause that employer financial loss, when in fact, presumably you've been working for about 2 years or more than a year from home. Or if you have reasonable proposal to the employer that will ensure that those reasons that the employer is providing can be met, then in that case, the employer have no cause whatsoever to refuse or to unreasonably decline to grant that request. But someone might ask, lawyer, is the employer not going to dismiss me if obviously my request is not considered within the 3 months, I don't get decision on my request, and if I continue to resist to be working from home, can't I be dismissed? Now, the answer here is quite simple. First and foremost, because the law makes it clear that the employer has 3 months to make a decision on this request, if the employer so decides not to consider this request within this time frame, then you have a right to make a complaint to the employment tribunal. And the employment tribunal might be able to find the employer, or the employer might lose this case in a sense that the employer might not probably have either given a good reason for declining your request or have not considered the request at all as required by law. In that sense, you could be entitled to compensation. However, if the employer, because of the fact that you have made this request, decides to dismiss you, then of course, this will become what they call automatically unfair dismissal. But going further, it is also important to look at people's relationship with other staff at the workplace. Maybe when you make that request, maybe you could be aware that there are other people who are working from home. There are other people who are doing hybrid working. You perform similar job role or almost the same job role with them. Therefore, if the employer decides that he would rather prefer to give remote working option to some employees, but not you, or if the employer treats other people quite favorably by granting their requests and refuse your requests, then there could be further sanctions for the employer. And this might sound quite simple, but I've had clients who have contacted me. They've just had they've just had return from maternity. They have younger children. They have asked the employer for reasonable adjustment or flexible working. I need to be careful with my choice of words because obviously when I'm talking about reasonable adjustment, I'll be looking at disability claims, but I am quite clearly discussing flexible working. So if that new mother who has just returned to the workplace has made a request for flexible working, either to work from a particular time to a particular time, or even to change the shift pattern from a particular day to a particular day, there have been numerous cases where people have been refused and they don't know their right. That one, by not considering that request, is a breach on the part of the employer. Two, by refusing that request and not giving a valid mandatory reason, is also a breach on the part of the employer. And obviously, that employee also has obviously a right under the Equality Act. So normally, if, for example, employee have been treated quite unfavorably compared to another person in terms of some of these demands and requests, either for flexible working, for remote working, for change of hours, for change of location of work, for change of shift pattern. Now, if these requests have been declined and that employee is aware of somebody in that organization that obviously may have had his or her request granted for the same reasons, then we'll be driving towards the Equality Act. And this is where I want to draw viewers' attention to. Because I want you to know that you have numerous rights at the workplace. You have a right by law to work flexibly. And I've already made it clear that if, because of the fact that you are been working from home due to COVID for quite some time, then that right is even more entrenched in the sense that the employer must have a very good reason why that arrangement must discontinue. So in this case, the burden, what they call shifted burden, clearly shifts onto the employer to show why that favorable arrangement shouldn't continue. And I've already said that that request is mandatory to be considered within 3 months. And I've also set out those who are entitled by law to make those requests. And obviously, if you have worked for 26 weeks or more, then automatically you are entitled to that right. That is a right that cannot easily be breached by the employer. That is the right that can give you some form of financial compensation. It's a right that ensures that you enjoy the right to be working favorably and happily at the workplace without the employer interfering with that particular right. Because the employer interfering with that right could result in financial consequence to the employer. So tonight, having said that, I'm going to discuss quite distinct area of the Equality Act. The reason being that most people are familiar with what they call racial discrimination, obviously maternity, sexual orientation, sex, age. But people are perhaps not familiar with what they call perceived or associated discrimination. So my topic tonight, because of its nature, because of the fact that people working from home might have good reason, because they have younger children, because some of them, they have grandmothers, they have mothers who are quite old and frail, that they need to be around them to be working. So I'm going to take my time to explain what they call associated discrimination. So I will take viewers to the Equality Act, Section 13. But obviously, when we are looking at the Equality Act, we are looking at what they call direct discrimination. And I've already set it out on this platform when I was discussing discrimination. I look at various protected characteristics under discrimination. Those characteristics may mean race, and I always make distinction whenever I'm talking about race. Race is not just about black and white person. Race relates to ethnic background. So if you are working with an Asian person and you are from Africa, and there is a favorable treatment, or you have received adverse treatment because of your ethnic background, that in itself is discrimination, racial discrimination. If because of your sex, because you're either a woman or a man, and you've been treated either favorably or unfavorably because of that sex, that is discrimination. If you are pregnant or you are maternity leave and you have been treated unfavorably because of that protected characteristic, that is discrimination. If you have religious belief and because of that you've been treated unfavorably, for example, if you are a Christian and you feel that Sunday, it is not a day that you want to go to work because you are a Christian, and you're asking your employer, give me off this Sunday because I need this Sunday to worship God because of my religious belief, and the employer so refuses, I'm telling you tonight, you have a right under the Equality Act, because that clearly is a breach of your religious belief under the Equality Act. Having elaborated these areas of the Equality Act, and obviously for those of you who have knowledge in law, I'm talking about direct discrimination under Section 13 of the Equality Act. I hear clients, prospective clients, I hear all kinds of things that are going on at the workplaces. And it's not because these employers perhaps are wicked in nature. It's because they don't know these employees have these rights. But quite sadly, these employees equally don't know they have these rights that protects them to be working remotely, flexibly, hybrid. But if you are not familiar with that right, then of course, you will not know how much compensation you could be entitled to for that unfavorable treatment. And this is why CITI Law Solicitors is here to create this awareness for people to know their rights at the workplace. Because there is a law that protects everyone at the workplace. In fact, there are various laws at the workplace, including health and safety. People having injuries at the workplace because the employer have not put certain things in place, and then they are only going for sick leave without claiming compensation for their injuries. Quite clearly, these people don't know their rights. And that's why each time I'm here, I am urging you watching me tonight, share these videos because people need to know their rights. And it's those rights that will set those people free from those suffering and the captivity. Now, going back to my topic, not to digress, obviously, is to tell you, you have various rights. Do you want to work from home? Do you want to do hybrid working? Do you want to change your hours of work? Do you want to change your location of work because perhaps you have bought a property outside London because London is probably too expensive for you? My question to you tonight is that, is your employer refusing to grant this reasonable request? My advice to you tonight is that you are entitled to compensation if the employer so refuses unreasonably to refuse this request without the mandatory reason. And I have already set it out what those reasons are. I had a bit of technical hitch when I was starting this program, so I'm sure that most of you might not have obviously followed up because I had a little bit of hitch when I was starting this program. But quite clearly, it's important that I take viewers through all these things in the sense that people need to know their rights at the workplace. So, having come to the middle of this discussion, obviously looking at people's right to flexible, remote, hybrid working, and the fact that those people could be deprived of these rights because they could be forced to return to the workplace, even though because of COVID, they have been working unrestricted for the benefit of the employer and to themselves, because the arrangement in place obviously is quite favorable one. Because you could probably use your line time to go and pick your child from school. It saves you childcare costs. It saves you commuting or transportation costs. And that right is protected under the Employment Right Act 2002. And this is a law that has been in place since 2003, 6th of April. And that is what I am discussing tonight. So it's important for people to know their rights. It's important for people to be quite familiar with these protected characteristics when it comes to the Equality Act 2010. And obviously, as I am saying, if you have any of these circumstances, for example, you might not have any disability, but sadly, you probably have a child who has disability. Or you have an adult, you have a parent, a dependent who is very vulnerable that requires your care. Therefore, during COVID, when you had the opportunity to be working from home, it was the best that you could ever get. And now, that right is at risk because your employer, having become aware that COVID restrictions are no longer in place, you're being dragged to come to the office, even though you could efficiently do the same work from home. Now, if you are in any of that category, then I'm making reference to the Equality Act, Section 13, which talks about direct discrimination. And that discrimination could be extended to what they call associated discrimination. That associated, normally, as I've said, if you have disability, obviously, you as an individual is entitled to reasonable adjustment. So if, for example, you have disability and working from home is quite favorable to you because of the fact that it saves you the stress of commuting and going to the workplace. That in itself is a distinct right protected under the Act. But by extension, I am talking about someone who has disability, not you yourself, but that person is reliant on you for his or her care. Then under the circumstances, this is what they call associated discrimination, which means that if you so request for flexible working because of this disabled person that you are caring for, and the employer so refuses, then without any good reason, that becomes direct discrimination, disability discrimination, or associated discrimination, because you are associated with that person who has disability. Now, having explained associated discrimination under the Equality Act, there are many of you who will also receive adverse treatment under direct discrimination because of your race, your religion, or your religious belief, your sex, your age. So, if, for example, as I've already said, we have different groups of people working at the same workplace, and some have been allowed to work from home, and you decide that you also want to work from home because you probably don't even have any disability, you don't have anybody you are caring for. In fact, you don't have to have somebody you are caring for because that law came to an end 2014. From that onwards, you could reasonably ask for flexible working without having any dependents. Prior to 2007 and 2014, you probably would have to show why you need flexible working or working from home. So this right of working from home has always been there. But COVID entrenched that right. So if, because of your ethnic background, not necessarily because you are black and the other person is white, your request is refused, and the other person who is white or who is Caribbean and you are African, request has been granted to be working remotely, then that clearly is race discrimination. Therefore, whilst you are even still employed by the employer, I want to tell you that you could still be entitled to compensation for that adverse treatment, for that unfavorable treatment, as long as you're able to demonstrate that someone else has been granted the right to work remotely or hybrid working, and you have been refused that right, then there is that shifted burden for the employer to explain why other people should be working remotely and not you. And that is the protection that you have under the law, even when you don't have disability. So tonight, I want viewers to understand that, one, they have a right to work flexibly. And that right to work flexibly includes the following: change of hours, change of shift, change of location, right to request change of location, right to work from home, right to work hybrid, which means that you work sometime in the office, maybe a day or two in the office, the remaining days of the week in the house. So there are various reasons that you may want to adopt any of these arrangements at the workplace. Therefore, if you are been employed for more than 26 weeks, then automatically you are entitled to that right. And when that request has been made because of the fact that you want to continue to care for your younger child, or because maybe you have a vulnerable adult that you are caring for, or because you want to save money from commuting or transportation. And this goes to those of you who, for example, have been working continuously during the COVID from home. So whenever you've been asked to return to the office and you make this request, the employer has 3 months to consider that request. And within 3 months, the employer must make a decision. And if the employer so decides that they will not grant you that request, they must show mandatory reason. Employer cannot simply refuse without giving mandatory reason. One, it could mean perhaps they cannot meet the need of a customer, or it's going to cost them financially. Because you will notice that there are some of the arrangements that it doesn't cost the employer anything at all. But why this topic is so important at this particular period is the fact that if the employee has been working from home continuously, and that arrangement has not caused that employer financial loss, then that employee's right to working from home becomes more entrenched, in the sense that there is that shifted burden on the employer to show why that arrangement should be discontinued. And if the employer does not give a valid reason for refusing that request, or fails to consider that request, that employee is entitled to make a complaint to the employment tribunal to claim reasonable compensation from the employer. But quite clearly, if the employer, because having refused this request, or the employee having threatened to make a complaint to the employment tribunal, so decides to dismiss that employee, then that becomes automatic unfair dismissal. But most importantly, my conclusion is looking at both associated discrimination and discrimination itself. And this is the part that I want viewers and listeners to be much aware of, because most of you have various rights within this area where one person has been treated favorably. Favorably in the sense that somebody doing the same role with you have been given that luxury to work from home, and you have been forced to come back to the office to work. As I've said, I have a friend who have just told me he has to resign because the employer have asked him to come to the office to work without any good cause, no good reason whatsoever, even though he's been working from home, and because he has just purchased a property quite far from the workplace, thinking that this arrangement will continue. He has to, obviously, because of paying mortgage, he has to give up the work and forfeit his right and all the benefits that come with that particular job and get a job somewhere else. Such person obviously has a protected right. But she gave up everything simply because he doesn't know his right. And coming to the end of this discussion, I have also said that there is also what they call associated discrimination, which means that if you are associated with somebody, either because that person has disability, that person is a vulnerable adult, and for that reason, you require, or you need, or you have a younger child, and for that reason you want to continue to be working from home or remotely, then you have that right to continue to work. And if you are deprived of that right, because of the fact that you are associated with somebody who is a vulnerable adult or has a disability, you can claim, even though you are not disabled yourself, by being deprived the right to work from home and take care for that disabled person, you could claim what they call associated disability claim against your employer, merely by depriving you that right. And this is the technical aspect of the law. But quite clearly, flexible working, remote working has come to stay. And people must know their right. And I know that I am canvassing for this right because I know that there are people in Ghana, America, all over the world that may be working from wherever they are whilst having an employer in the UK. And there's going to be a time that obviously I'm going to have another discussion in this area. And for those of you who are watching me from Ghana, you must be thinking quite broadly, because we are moving to another era of the world where people can be working globally. If you're an IT professional, you probably can be working from Ghana and providing your service to a company in the UK. If you're a teacher and you have qualified, you probably can be working from Ghana and be teaching a child here. People must think broadly, because the law is there to enhance these services in a sense that it becomes so competitive that we can get the best out of them. I don't want to bore people with economics because tonight I'm just talking about law. But obviously I'm urging those of you watching tonight, either in Ghana, in South Africa, you must be thinking of providing your services globally. Because remote working has come to stay. And obviously, most people have been giving lectures remotely. So why can't you lecture from Ghana? Why can't you even do a course and be able to teach people from Ghana? And obviously, when people are complaining about unemployment, Have they looked at these areas? This is a matter for another day. But tonight, I am bringing this topic to an end by giving a short 1-minute summary. And if for whatever reason, whilst I'm giving a summary, anybody have any legal question, I am here to provide that advice. This is just a short reminder that every advice given here is for guidance only under the City Law Solicitors disclaimer that you must seek your independent advice if you want to make a claim for any of these stuff that I have discussed here tonight. And it's for that reason I must advertise City Law Solicitors to you, because obviously City Law Solicitors is specialized in numerous areas of law, and therefore it's important that we let viewers and the public know of some of these services that we provide, so that people can receive specialist employment law advice on flexible working and right, especially if you're an employer, how to avoid getting unnecessary compensation from employees. Because gradually people are becoming very, very much aware of their rights. So if you're an employer and you are not thinking of recruiting a lawyer to advise you on some of these cases, be watchful, because soon somebody may be making a claim against your company because of not following some of these rules. I'm sure most of you might think that, oh, because you have offered a job to somebody, that person doesn't have a right to even ask for flexible working. You are not obliged to consider it. And tonight, I'm sure, having make references to the Employment Rights Act 1996 and 2002 and Equality Act 2010, most of you clearly are going to be very much aware that these employees have these rights protected by law. I just have to let viewers know that this program is proudly sponsored by City Law Solicitors. City Law Solicitors is located at Barking. We specialize in various areas of law. If you want to look for City Law Solicitors, we are located at Barking, Unit 113, Barking Enterprise Center, 50 Cambridge Road, Barking, IG 11 8FG. And obviously, if you want to call us, our office telephone number is 020-3355-0782. And if you have any legal issue or problem in any of the following areas that I'm going to mention, don't waste time. City Law Solicitors is waiting for you. If you have immigration problem and you need specialized immigration advice, City Law Solicitors will specialize in nationality law, asylum law, and obviously immigration. If you have any employment law matter or problem, if you're an employer and you need an employment lawyer to advise you on how to stay out of trouble, don't go far. City Law Solicitors is here to help you one stop. If you're an employee, you're having problem with your employer, either because of discrimination, unfair dismissal, you are being made redundant, you want to sign your settlement agreement, City Law Solicitors is here to assist you. Family law, City Law Solicitors, we are not just specialist solicitors in the family law. We are family law accredited. So if you bring us your family matter, your matrimonial matter, children law, we will be here to assist you. If you have a problem with the council interfering in your life and trying to take away your children, we are here to defend you. If you are going through divorce and you need a lawyer to assist you in your financial application so that you can reinvest some of the matrimonial pot that have been accrued in the course of the relationship, we are here to help you. If you want to have child arrangement order in place so that you can see your child, we are here to help you. If you are being made to leave your own home because your partner have made non-molestation and occupation order application against you, we are here to defend you. If you have suffered domestic abuse and you want to make non-molestation order or occupation order against that person who is perpetrating this abuse against you, we are here to represent you. And of course, if you ever had accident at the following places that was not your fault, CITI Law Solicitors, we are also here to help you. If you had accident at the workplace, if you were in a car and you had a motor accident, we deal with personal injury. Therefore, we'll be here to represent you to get that compensation that you rightly deserve. And if you went for treatment and had a problem with that treatment, clinical negligence, we are here to also assist you. Commercial disputes and civil litigation. If you're a company, you need a company lawyer to advise you on your corporate affairs. Last week, I discussed extensively corporate insolvency on this platform. If you want to have partnership agreement in place, if you want to recruit and you need a lawyer to draft proper contract of employment to protect you or your company, CITI Law Solicitors is here. Don't go far. If you only have housing disrepair matter, CITI Law Solicitors is also willing to assist. So tonight, it's been privileged having you tonight. And I want to thank all of you for coming on board. I know that I had a technical hitch right from the onset, so most of you probably will not have had the opportunity to watch this program, but you can still share the program with your friends and family members, and I'm sure that any of them that is having any of these issues can learn something from what I've discussed tonight. And if they want to have specialist employment law advice on this flexible working, we are here to also give them advice on those rights so that they can continue to enjoy working with that employer without hindrance and frustration. So I want to thank all of you tonight for coming on board and for watching us. And obviously on Thursday we are going to have the chief version. MC Chaka is going to be here to assist us so that we can continue to give you that free legal hour that is proudly sponsored by CITI Law Solicitors. Thank you so much for watching us tonight. Thank you.